Good evening, ladies and gentlemen, and welcome to another edition of What's Happening. I'm George Binns, and I'm here with my co-host, Elliot Margolis, and we have this evening for a return engagement, Stu Gardner, attorney at law. The reason we're bringing Stu back for a repeat performance is we had a discussion a while back about how you get your act together so you can pass on the information about what you
wish you wouldn't say pass on.
Yes.
Try just a different terminology than pass on.
Truth hurts, Elliot.
Okay. Anyway, to transfer the information.
There we go.
Okay. To somebody who's going to help you out. And after you do that, then the question is, what do you do next? And what brought this up this time around was there's going to be a workshop at the Senior Center talking about protecting your home and savings from mass health and nursing home care, which nursing home costs, which is the 5-year look-back concern with the Medicaid. And then the library had an interesting book, Estate Planning. And this is by a gentleman by the name of Dennis Clifford, who writes for something called the No-Low Press. So if you start to get your act together, and then you go the next step into what do I do to protect the funds and make sure they're still there, the issue comes down to one of, can you really get to looking at a seminar like this at the Senior Center or a book on estate planning, and can that get you started, or at what point do you need a lawyer?
Well, I'm a lawyer, so I'm going to say
Yeah.
as soon as you walk through the door.
That's why I asked you.
I think it's difficult. A lot of my clients, and I actually do a free clinic at the Senior Center as well. They want to be able to do something themselves. A lot of times you can't. A lot of times, especially if you want something more sophisticated to protect your assets from nursing homes, from stuff like that, you need a professional. You need a professional to do the mass health application. I don't know if you ever pulled it up. Now, I'm no mass health application expert, but the application's 10 or 11 pages, and it's very detailed and very confusing. And there's professionals out there. There's a couple of people in Beverly actually that do it. That you pay them a fee, and they help you complete that application. So the short answer to your question is, unfortunately, if you want something, if you're protecting a $500,000 house, you may have to spend some money to complete that protection.
What kind of money are we talking about?
So that could depend. Obviously, for the application process, it's not as much. I mean, that's hiring someone maybe a few $100s or $300 or $400. But a lawyer can run anywhere from $2,000 to $10,000 to protect an estate or assets or whatnot from mass health. If I can jump around for a second, there's some misnomers out there, and I just want to make sure that this is clear, is that no one's going to get kicked out of their house. A husband and wife that own a house, if someone does need to go in a nursing home and mass health does come in and pay for it. I mean, basically what you're saying is, I can't pay for the nursing home. I need some other entity, an insurance company, the federal government to pay for it. And that's what mass health is. It's Massachusetts Medicaid.
Yep.
And that's the application process. And the application basically says you got to be broke. I'm not super familiar with the requirements, but you can't have any assets in your name. And so what clients want to do is say, look, I want to get the assets out of my name, so when I do apply for this, I can get it. And if you don't, what will happen is mass health will pay, oftentimes if you qualify, but then they'll put a lien on your house. And that lien has to be satisfied when the second spouse passes away. So obviously there's other rules where if there's a special needs child in the house, it doesn't get sold and whatnot. And there's other things that are down the line, other rules. But basically, no one's going to get kicked out, but the beneficiaries, the kids, will have to satisfy that lien. And it can be, nursing homes can be $15,000 a month.
Oh, yeah.
So you're talking about, a couple years, that's probably the value of the house. What some of my clients do, which I don't think any estate planner recommends, is just say, I'll just give my house to my kids. I'll take the deed and I'll couple $100 and I'll just give it to them, which is just a host of problems. First of all, unfortunately, I've seen kids that don't want their parents around anymore. So you give the deed to your kids, and your kids have a bad day and they say, Mom, get out. And then mom's on the deed and mom has to leave. And that happens. You're also subject to your kids' troubles. Kids go bankrupt. Kids get divorced. So if you transfer the house to your kid and then your kid gets divorced, half that house belongs to the kid's spouse, which is not what you intended to do when you gave the house to your kids. Jumping around a little bit, you were talking about the 5-year look back. What the 5-year look back means is that whatever you decide to do, however you decide to transfer, and I'll talk about a few more options, is that the government will not count that as a real transfer for 5 years. They'll think it's illusory, for lack of a better term. So you have to wait. It's like a penalty period. You have to wait that 5 years. It used to be 3, and they're talking about a 7-year look-back period, simply because nursing homes are really expensive. Yeah. Medicaid doesn't have the money, and they want to get money from people to pay their own. So obviously, one of the options and I'm sure they'll discuss it in this thing, is giving the house to a kid, and that's obviously for those reasons, for those pitfalls. I certainly don't recommend it. Another option is something called a life estate. Are you familiar with that? Yeah. So a life estate says, I'm going to give the house to my kids. It's in the deed, but I'm going to reserve a life estate for myself. So the deed says, Stuart Gardner gives the house to Lucy Curtis, my daughter, but for the rest of my life, I can live at the house. It's my house. It's kind of another less expensive way to do it, and somewhat effective, but also has problems. Now I can't borrow against the house without permission from my child. There's also value in my ownership. In other words, so Mass Health can say, well, you're only 50 years old. Your life expectancy of a 50-year-old man is 30 years. You've got 30 years in a house, in a nice house. Your value could be $200,000. So they could actually put a lien on that amount because that life estate has a value. So again, it's an option, less expensive, but not great. I always, I'm not an insurance salesman, and I'm not affiliated with any insurance companies, but I'm always for if you can get long-term care, if it's available, that's a great option. I've got clients that were smart, that purchased long-term care, and that covers, $12 of the $15,000 a month. So you're not talking, it's still money, but not money that you'll lose your house. That's always a good option. Obviously, if they're elderly, the long-term care premiums, I can't speak personally about them, but I'm sure they're very expensive for people. I'm sure it's cost prohibitive.
Yeah, I mean, the risk is increasing, so the insurance companies want to cover that risk.
Exactly.
And they're going to charge a higher premium for it.
So what do you think about, say, reverse mortgages, number one, because that's
I like reverse mortgages. It's money borrowed, so it's not counted against his assets, right? And it's a way for them to pull. The only problem with reverse mortgage is it's a mortgage, right? So you're going to give the money to your kids. What most people want to do is they want to leave their house for their kids. If you do a reverse mortgage, most likely the elders are going to spend the money, do something with it, or maybe they'll invest it or something like that. But it won't serve the purpose of passing the house on to your kids without debt. So I'll come back to reverse mortgages. Let me just say the other thing that people like to do, and this is the more complex thing, are the irrevocable trusts. And a trust, as you know, is a legal entity that holds title to property. And a well-formed irrevocable trust hopefully will prevent Mass Health from taking the house. Basically,
what do you mean, hopefully?
You never know. I mean, each case is different, and each deal. Mass Health is a large bureaucratic organization. Depending on which officer you get, does it get bumped up to the head attorney? Does does someone look at it briefly and say, oh, it's an irrevocable trust, we're not going to touch it? In other words, it's more of an art than a science, for lack of a better word. But what an irrevocable trust says is, okay, I'm going to put this house in trust, and the interest of this house is allowing me to live there. So I don't own the house anymore. The trust owns it. I can still make decisions about it. If a bank will lend me money, I can still borrow against the trust as long as the money stays in that irrevocable trust, and I can live there. But when I die, that trust automatically passes to my beneficiaries, hopefully debt-free.
I was under the impression with an irrevocable trust, you have a trustee who is not you; it's somebody else. So isn't that similar to the case of you give the house to the kids, depending on who your trustee is?
So you can be the elder can be the trustee, doesn't have to be. And again, remember the trustee's just following the instructions of the trust.
Yeah.
So if you do make your child the trustee, right? It's still, I can live there for you allow the beneficiaries, the parents to live there for the remainder of their lives, and when they pass, take this house and sell it and distribute it to you and your brother and your sister.
Yeah.
So, some planners don't like, some planners say, let's keep you off. We don't even want you as trustee because maybe there's a conflict there, or we want to make sure that this trust does survive the mass health test or whatnot. Some planners say, you know what, you want to be in control and still get the stuff, and you want your name on it and whatnot. It's a little. There's some disagreement in the legal community whether you have to make your child the trustee or not. And just for the people that don't know, the trustee is the fiduciary charged with following the instructions of the trust.
But if you don't have a trust, then it goes to probate.
If you don't have a trust,
And
it goes to probate.
And probate can not only be expensive, but can take till who knows how long to get done.
Probate is an archaic process. It's been around for 300 years, and I don't think it's changed much since then. Dealing with the house, you have to go, an attorney would have to go to court, sometimes 2 or 3 times. Probate is the process of making a will public. And you have to follow a bunch of rules, and unfortunately, you oftentimes put an ad in the paper. Or people just know that the person died. And probate court's like the people's court. In other words, so if you go to Superior Court, some of the judges are really persnickety about the rules. These are the rules you have to follow. I don't care if you're a lawyer or a layman, right? These are the rules. Probate court, because they deal with divorces and families and people coming in and deceased people, they kind of let anyone say what they want. And you could have a claim against an estate. I always recommend any of my clients that come in that are over 50 or 60 years old, I say, let's get your assets out of probate. Because if there's any dispute at all, you'd be surprised. The old adage, the relatives come out of the woodwork. Uncle Joe, Cousin Sam, Auntie Jean loved me, and she said I could have $100,000. And the claim may have no merit. It may be a worthless claim, but the judge will hear it. And it will take the person in charge, the administrator, the personal representative, or the trustee, or whoever's handling the probate issue. Could take up to a year, you're right, or 2 years, fighting this kind of frivolous lawsuit. It costs $30, $40, $50, $100,000 defending a lawsuit that has no merit. All because you just threw the assets on the public domain and said, whose are they?
So if you want to avoid the Megillah of probate...
Megillah, I like that one.
Thank you. What's the best way to handle...
So definitely a trust. Because
revocable or irrevocable, and what's the difference between the two?
So irrevocable, I don't want to answer a question with the same words, but irrevocable says you really can't change it. This is the trust. The reason why you do it irrevocable is because what the government says is if you can get to the money, so can we. So my wife and I have, I'm just making this up, we have $1 million, we have $1 million home. And we want to make sure that if we need to go to a nursing home and Mass Health has to pay for it, it goes to our kids. So I put the house in this irrevocable trust and say, I can't touch it. I can live here, right, for the rest of my life, but I can't touch it. So now the government says, okay, well, we're going to put a lien against it. It's not mine. I can't touch it. You can't touch it. Clients with high net worth clients, someone with 7 figures in the bank, right, that can make a lot of interest on their stock investments or whatnot. Let's say they're making $100,000 a year on their investments. Oftentimes, you could put the stocks or the money into an irrevocable trust, and they can live off of just that interest. You say, okay, you're not going to touch the big money, right? The big money you don't need, but we're going to let you live off of that interest, and it's also hopefully a non-countable asset, so that when they do go and ask for Mass Health, it gets paid for. Which is another conundrum, because why is someone with $1 million in assets need to go to Mass Health? But that's probably a different show.
Okay, now you live in an apartment.
Yes.
You don't have a house, but you need Mass Health.
Well, those are the easy ones. I mean, most people. I mean, again, I'm not a Mass Health expert,
right,
but I think it's a lot. The people that come to estate planners are the ones with some sort of asset, some sort of big asset, a house, some money that they, and I completely understand. I empathize with them. They worked very hard for it. In fact, maybe how hard they worked, it contributed to their detrimental health. Maybe they worked 2 jobs, or maybe they worked with asbestos, or maybe they worked with something that was, as I said, detrimental to their health. And they look at me and say, "Damned if I'm going to give this house to the government. I worked hard. I want my kids to have it." And so what they have to do is sort of go through this whole rigmarole of trying to lock up the assets, and make it irrevocable. Revocable trust, to what you were asking before, is more like a probate avoidance trust. You can make changes to it. That's for things like, I got 3 grandkids that I really like, but one I'm not too sure. I see them smoking pot all the time. One I'm not so sure about, and I've got some money. I want to leave them all $100,000, but I certainly don't want to give them $100,000 because it'll, they'll buy a car and crash it and spend it on drugs. So what I want to do is I want to make sure, almost like I was here, like they could call me up and say, Auntie Joan, my rent is due, my electric bill's due, my college is due. The beauty of a trust is it lives on when you die. And you could put specific instructions about what you want. I want them to go to a 4-year accredited college, and we'll pay for the college, and they can't have the majority of the trust until they graduate. Or I want drug testing. I've had clients that said, I don't trust my kid, and a good kid, but I'm afraid. I want them to go in once every 6 months and pee into a cup. And as long as the drug test is clean, they can have that 6 months worth of money. If not, they can't, or they have to go into rehab, or something like that. And that's the beauty of a trust. And to boot, you avoid probate. You've taken your assets out of your name, and you've put them in this trust. It all depends, you've covered the whole sort of spectrum of clients. It all depends on what the particular client needs. And I know this sounds like a caveat, but everyone's different. Some people don't have any concerns. Some people look at me and they're like, my kids are like gold and I'm not worried, and blah, blah, blah. Some are like, I love my kids, but they're not too good with money, and stuff like that. So that's your revocable versus your irrevocable trust.
Well, basically, you can write a will with all these instructions in it, and you're telling me that the will is good if you can get it through probate.
Exactly.
And if you write the same set of instructions
in a trust,
it's
not public.
It's not public,
Nope.
And the instructions are just as valid.
Yep.
But probate never sees it.
So, yes and no. They won't see it in the beginning unless someone sues, and probate court is the court that has jurisdiction over trusts. But again, 3/4 of the battle is taken care of because it's not public, right? The will, you got this whole procedure where you give the will, you have to send the will into to probate court, and it's on file. So you die, everyone can come through and look through it, right? And
so, let's back up a little.
Sure.
You're saying with a trust, you don't publish the will, you don't publish anywhere around that so-and-so died, and all you creditors have so much time to go make your claim.
So
that's what a probate does, right?
Probate says, yes, there's a hierarchy of who gets paid first.
Yeah. But there's also a hierarchy. You've got to go notify people.
Yes.
And publish
it
in the local paper, right, and all the rest of it.
And the creditors show up, and anyone that you owe money to and stuff like that, and all those people get paid first, and then if there's anything left, the bequests get paid.
But yes. It sounds like if you don't make this public announcement, but somebody reads the obit paper,
right,
and they find out, oh, Sam died last week, he owes me money, even though he's got a trust, they can go to probate court and say, wait a minute, he owes me money before you do anything with it, I get my share.
So did they have a trust or did they have a will?
They had a trust.
So, no, yes and no. So
that's when this yes and no is bothering me.
Well, I'm a lawyer. Yes and no.
Yeah.
If there's a trust system, right, and they have no probate assets, but he does read the obits, right? So he's not going to know that there's a trust. He's not going to know. I mean, it would cost him. There's a barrier to entry, I guess, is my point. So you'd have to get a lawyer. You'd have to go to probate. You'd have to file some sort of petition to the estate, and then they would say the estate is insolvent. It's very, because the estate is insolvent because all the money's in trust. You can sue trusts, but it's very difficult because you don't know them. You don't know what's in the trust. You don't know who the trustee is. You don't know anything. it's like the discussion we were having before. It would take you 2 years just to figure out the starting point. So yeah, I guess if the estate in question is $5 million and you think you're owed $1 million, you're going to spend the money. But this gets rid of anything under $100,000.
So even with a revocable trust, you're still liable to have somebody come out of the woodwork.
You could sue anybody. Yeah, I can't. But you've just eliminated 90% of the problems.
Okay, so you still got the 10% problem left over. Okay.
Yes. Well, I mean, you can sue anyone for anything.
Oh
nowadays.
yeah, I understand that. That's
so yes, but you eliminated, as I said, 90% of the problems by putting it. I can't disclose.
So if we go one step further and make it an irrevocable trust,
It's harder to crack. The only problem with irrevocable trusts,
can they sue an irrevocable trust?
you can sue anything, yes, but it's harder to get to. It's harder to get to the money because there's trusts have these things called spendthrift clauses, and they're ways that the money can only be used for certain things. So what a good trustee would say, you'd sue me and say, I want my $1 million, and I'd say it's an irrevocable trust, and the trust only allows me to pay out, $5,000 a month, and the first expenses are here. So you could put a lien against it, but you'll never get it. You're kind of getting into some detailed legal philosophy, but basically,
Well, I'm trying to get at is this thing really as good as it appears? It's not ironclad, is what you're telling me.
well, George, nothing's
I
ironclad.
understand. But
Put your money in the mattress.
I understand. But you laugh.
You collect about, you
I'm going
collect
to
the
George's
same,
house after this thing.
yeah, but
No,
you
the
collect the
first
same amount of
mattress I
interest as you
bought-
do at the bank.
Yeah.
Had a zipper in the back,
Yeah.
and it was a little sleeve that
For
you
the
could
money.
literally.
I like
But
it.
anyway,
So yes, I guess if ironclad is a difficult concept. There's levels of protection. So no will, no protection. A will, a little better, but will goes to probate. Deals with probate stuff.
Yeah.
Revocable trust. Again, knowledge is power. Who are you going to sue? You're going to have to. Again, you have to. If some client came off the street to me and said, my uncle, I think he had a trust. I don't really know. Maybe I'm a member of it. I'd probably ask for 5 figures to even get involved, because I'm shooting in the dark. What am I?
Okay, question now. You talked about no will.
No will. Called intestate.
All right, so couple of questions. Number one, somebody passes away.
Yep.
How do you know where the will is? Number one, because I did my will with you and then I moved out to
Sure.
Colorado.
Yeah.
Who's going to know?
No one's going to know. People ask me this all the time. Like, what's the procedure? So what I do when I do an estate for someone is I give them a book. First of all, I keep a copy of the will. So I haven't signed 2 wills I keep copies of everything. So I give them a book that has my information and all that kind of stuff, and I say, put this with your papers. And then I say, tell whoever you make, let's say usually the parents make their eldest son or their eldest daughter in charge, tell them where it is, right? I know this sounds kind of really informal, but that's the way they do it. I see I'm on a lawyer chat board, and 4 times a week I see, did anyone know Jane Smith, we're looking for the will because she just died, and the lawyer's long gone or whatnot. There's no central, the probate court's it's an old system, no one uses it, no one I know uses it, but it's like $50 or something like that, and you can record a will there before you die. People that
Be hard to afterwards.
yeah, exactly. We could. Try. They call it the zombie will. So there's really no formality to it. It's more like, who is this lawyer? Where are they located? Who knows where the papers are? I have more clients that, their parent, if they come to me after the parent dies and they'll go, look, we've been looking through the papers, we can't find the will, we found this insurance policy, we found this. Back in the 50s and 60s, there was a paper trail. Nowadays, no one even knows where they keep their papers. It's like everything's online.
it's on a
But
computer.
if you have no will, and the reason for this question is
Yes.
obviously for our listeners, if you don't have a will, you should get one.
Yeah, oh yeah.
And what happens to all their money or all their estate if they don't
Comes
have a
right
will?
to me.
Well, it goes to you in the cost of your fee anyhow.
Exactly,
So.
the intestacy rules. So there's a procedure and system and hierarchy of who gets money if you die intestate, and it's obviously the bills get paid first. So the lawyer and the person running the show gets paid first, then the funeral home, then expenses of last illness, and then creditors. And if there's any money left, and then it's like the spouse gets an elective share if she wants it. I think it's 50%, or the whole thing. And then there's if they have kids, if they have parents, if they have brothers and sisters. So it's a whole sort of family tree. And if they can't find anybody, it escheats to the state, which means the Massachusetts takes it.
So the reason to have a will is if you don't want a particular kid to get
Yeah.
money,
Yeah.
Or if you
You're
don't
gonna-
want the state to just
or
take
if you
it
don't
all.
want
Yeah.
the state to just take it, I mean, they take enough as it is.
Well, plus the whole conversation about why go to probate. Not only make it harder for probate with a will, it's twice as hard without a will, because you got to follow all these rules, and then you got to deal with the paper, and you got to deal with it. It's a long, arduous process that the only one that makes out is the attorney.
Yeah.
How much does a will cost to
I'll
to
do a simple will for a couple for like $600. So, which is pretty good. I know other attorneys out there more like $1,000, but I try to give people a break. So
But that
I
way,
think it's a break.
That way, at least you, for $600,
Yes.
you're
Little
protecting
peace of mind.
all your assets.
Yes.
And you're making them go where you want them to go.
Exactly. And just let me add, for that I'll also do, what we talked about last time, and I don't want to confuse everybody, but the power of attorney and the healthcare proxy,
Right.
which is also really important documents. We talked briefly about power of attorney last time. 40 years ago, a husband could walk in when his wife was ill to the bank and say, I want to sign on her behalf, and they would let him do it. But recent laws and obviously case law and realism that sometimes spouses don't have their best interests in heart. Now you need the power of attorney. And you need that document that says you can sign for somebody else. And without it, it's useless. It's tough. Truthfully, it's tough with the power of attorney. I go to banks all the time. I was at a bank the other day for the client. And I won't mention which bank. I really want to because I was really annoyed. But I won't. but the power of attorney clearly says I can go in the safe deposit box. It's right there. I had him do it. I even had the principal, giving me the power, initial next to the part because I knew I was having trouble getting the safe deposit box. It took me like an hour and a half to get in that safe deposit box. All I'm trying to do is get something for the guy to give it to him, right? I'm not committing fraud. I'm not stealing millions of dollars. There's a paper in the safe deposit box he wants. And he's an elderly man, and I can't get it. And I swear, it took me 2 hours at the bank. So even with the documents, it's trouble. So imagine without them, you'll never get anything.
Right. Yeah, no, that I've been through that kind of a course before, and it can be difficult.
Yeah.
We don't have a lot of time left, but if there's something you'd like to just do an overall overview of what we've talked about,
A little dance.
I'll give you,
Sure.
if I gave you 30 seconds, you'll take 90. So.
Yeah, sure. Well, I guess the thing that you were talking about this show was about what to do if you want to protect your house. A lot of my clients, their biggest asset is their house, and the choices are don't just give it to your kids. That's my advice because again, there's problems with their creditors or their problems. The life estate's a decent option, not the best. Irrevocable trust for some people is the perfect option. For some people, it's not. You have to go see an attorney. Call me. You put my number up or whatnot, or go see. There's a lot of good estate planning attorneys in this area because there's a lot of elderly people. Go see an estate planning attorney. Sometimes you have to spend money. I know a lot of my clients don't like spending money.
Right. Well, I'll tell you, Stuart, this was part 2 of what will turn out to at least be a part 3 because next time we'll talk about probate court, dealing with families and divorce and stuff like that. And that should be another interesting topic.
Happy to be here whenever you guys invite me.
I appreciate you coming again, and it was certainly a lively conversation. We didn't get a lot of questions in because I kept talking.
Yeah.
But
Well, I thought that's what you wanted.
it is. It makes the time go by even quicker. But thank you for coming again,
Thank you.
and thank you for watching, and we'll see you at the next show. Good night.